Hello friends, welcome to Abhinav Goswami Law Classes. So friends, in this video we are going to discuss section 2 of Indian Contract Act. This is a section regarding interpretation clauses. So it is defining very important terminologies which are used in the entire Contract Act. So that is why this lecture is very important. This is a basis. If you do not understand this terminology, it will not be possible for you to understand the law, the contract law. So friends, please pay your full attention and open your BR Act, open section 2. Okay. Section 2 starts with, in this act, the following words and expression are used in the following senses unless a contrary intention appears from the context. So what this heading is saying is that words, the terminology which we are going to discuss in the following sections are used in the senses in which they are defined. So they will refer to the meaning which are given to them under the following parts. Okay, but they are not straitjacket formula, and there may be a case that they may signify a different meaning, but all depends on the context in which they are used. But generally, normally, these terminologies, these expression will be understood in the senses in which they are being defined, right? The first definition, as far as the first definition of section 2 is concerned, it is in regard to proposal. What is meant by proposal? When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtain the assent of that other to such an act or subsistence, he is said to make a proposal. So friends, as far proposal is the first stage, first step towards a contract or an agreement. Okay, so what is proposal? So from this definition A, we came to know that there are a few requirements that must be satisfied. Only then a particular act will be said to be a proposal. What are those requirements? The first requirement is that there should be two parties, A and B. The second requirement is that one party should be signifying his willingness to do something or to abstain from doing something for the other. So there must be signifiance of willingness by one party to another. A and B, two parties. A is signifying his willingness to B, and this willingness may involve a positive act or an absistence. Okay, that this person may be saying that I will do something or I will abstain from doing something. Okay, it is not necessary that it has to be a positive act. So this person A has signified his willingness to do something or to abstain from doing something, but everything this person A is doing must be doing only with the aim to achieve the assent of this other person B. If the acts are not being done to achieve the assent of this person, then this will never amount to proposal. It will only amount to proposal when all of this significance of willingness and uh, and the act with the positive act and the abstinence from the positive act, this must be done so as to achieve the assent of the other party. Okay, if all these three requirements are satisfied, two persons sharing of willingness in regard to positive act or absence, and in order to achieve the assent of the other person, if these four requirements are satisfied, then what comes into four? A proposal comes into B. Okay, this is called a proposal. Now come to B. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So B provides a definition of promise. So B says, when this person A signified his willingness to do something or to abstain from doing something so as to achieve the assent of the other person, A has done everything what he wanted to do. Now, if the other party B has accepted it, gave his assent, accepted the proposal, then it becomes a promise. When the proposal given by one party who shared his willingness regarding a positive or negative act in order to achieve the assent of the other party, when that is accepted by the other party, it becomes a promise. Okay, as far as C is concerned, it deals with the terminology promisor and promissory. Promisee, it simply says the person making the proposal is called the promisor. In our case, A is the promisor, and the person accepting the proposal is called the promisee. In our case, B. Okay. D. when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstained from doing, or promises to do or abstain from doing something, such act or absistence or promise is called a consideration for the promise. So very important. Consideration is a very important aspect. Without consideration, no agreement can come into being. Okay, so proposal, acceptance plus consideration becomes agreement. So D is concerned, it defines what is meant by consideration. So friends, when this person A signified his willingness that he will do something, a positive act, or he will not do something, abstain from it, okay, in order to achieve the assent of the assent. What is this meant by this term assent? Assent is that in response to the act which A is doing or the existence which A is doing, if whether B is ready to do something or not, this is called the assent. If B is ready to do something in response to this act or existence, this is called assent. Okay, so if this person, the other party, we are talking about the other party, okay, we are talking about the promisee. If promisee in response to this proposal has already done something, or is doing something, or is going to do something in future, okay, this is what is consideration. What is consideration? The consideration is something which the other party is going to do, which the other party has either done, is doing, or going to do, past, present and future. So the other party, the assent, which the in regard to which the act or the existence in regard to which assent was given, that is what is meant by consideration. I understand, friends, you must be getting confused that what I am saying, because when we were discussing the definition of proposal, we were saying that this person A is doing an act or abstaining. But friends, we need to understand there are two parties. Both of the parties will do something for each other or abstain from doing something for each other. This is why this assent was necessary. B is not like that, I will not do anything. He also has to do something. So as far as the definition of consideration is concerned, we are not talking about the act or existence of person A, the promiser. We are actually talking about the act or existence, the response of B, what he is doing, what the promisee is doing, has done or is doing or is going to do. That is what the consideration is, because that is the reason that A initiated the process. A wanted B to do something, right? That's why he showed his willingness to do something for B, so that he will do something for him. Okay, so what was the basis? What was the, why will a person approach the other person? He approached for some reason. He want to achieve something. That's why he initiated it. So when he showed willingness to do something for B, in his mind he had that B in return will do this for me. So what A was expecting from B is consideration. So if consideration can be past, present or future. It may happen that B has already done that, or it may happen that B may be doing it right now, or it may happen that B is going to do that in future. So all of that is consideration. Okay, friends. Now come to E. Every promise and every set of promises forming the consideration for each other is an agreement. Okay. So friends, we need to understand that A is doing something for B or abstaining from doing something for B. Same goes with B. B is doing something for A and abstaining from doing something from A. Right? So what is this? What is this? What A is doing is a consideration for B. What B is doing is a consideration for A. So this is an exchange. So when these are accepted, these are promises. There may be one promise or there may be a set of promises. So all of these together becomes agreement. So what agreement actually involves, I will explain. There are two parties, right? One offered the willingness, other accepted, right? So what came into being? Came into being a promise. So when a promise came into being and there was consideration also, promise plus consideration became a agreement. Two parties, when they agreed to do something together, it became a promise. When promise was supported by a consideration, then it became a agreement. This is how you must understand. Okay. So now come to F. Promises which form the consideration or part of the consideration for each other are called reciprocal promises. So that's what I am talking about. Something A has promised, something B has promised. So these exchange of promises, they are considerations for each other. I told you what A is going to do is a consideration for B, what B is going to do is a consideration for A. So these are reciprocal. Reciprocal means that they are based on equal relationship. Both promises are reciprocal of each other. They are in exchange of each other. Okay. G. An agreement not enforceable by law is said to be void. Very simple. So this is very important. An agreement, because of whatever reason, it may be an illegal agreement, or a consideration may be illegal, or it may be not possible to perform. So whatever reason, if a particular agreement is not enforceable by law, not supported by law, not recognized by law, then all such agreements are void. This is what G is saying. H. An agreement enforceable by law is a contract. Okay. So agreement which is recognized by law, which is valid, where consideration is valid, everything is valid, it is a contract. And when it is not valid, it is not enforceable, it is void. I. An agreement which is enforceable by law at the option of one or more of the parties, and but not at the option of the other parties, is a voidable contract. Okay. So friends, don't get confused that what are those contracts which are enforceable by one party but not enforceable by other party. So when we will go into details of the contract act, we will come across a chapter which discusses with this only. Okay. So I will explain you then. But as far as our definition clauses is concerned, you need to accept that there are few agreements which are valid, which everything is valid, but they can be enforced by only one party. For example, A and B has an agreement, but the power of enforcing this agreement is only with A or with B. Both do not have the power to enforce. Normally, in a normal contract, in a valid contract, both the parties have equal right to enforce the contract, that you do something, you do that what you promise, or you do that what you promise. But in a voidable contract, only one party has the party to enforce, right? So an agreement, we came to know from F, from E, that when promise plus consideration became an agreement, now it is fine, agreement. But this agreement, this is fine, but agreement may take three courses. If an agreement is valid and recognized by law, it is a contract. If an agreement is not recognized by law or is invalid, it is void. If an agreement is valid but is enforceable by only one of the parties, it is voidable. So there are three courses in which an agreement may go. So this is what you need to understand. An agreement may be illegal, but a contract cannot be illegal. Why? Because the term itself refers to a valid agreement. Contract means an agreement enforceable by law. So how can an agreement, illegal agreement, can become contract? It will always remain at the stage of agreement only. Okay. So agreement can take three courses. It can either become a void agreement. I was only myself was making a mistake. Void agreement, or it can become a valid contract. We can use the term contract, or it can become a voidable contract. Why we are using the term contract with voidable, not with void? Because it is enforceable, it is recognized by law, but the only thing is it is enforceable by one of the parties. But void, it is not a contract, it is just an agreement, that too illegal. Okay. Now come to our last definition, J. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Okay. Just I just told you that an agreement which is illegal can never become a contract, right? Because an agreement means an because a contract means an agreement enforceable by law. But now J came. Okay, J is saying that Abhinav, you are not right. Jay is saying that, tell me, Abhinav, what will happen that a contract, when that an agreement when it was entered into, it was perfectly valid. When an agreement, when it was entered into, it was a perfectly valid, so it became a contract. But now, in future date, because of some reasons, because of change in law or whatever, that agreement is no longer enforceable by law. What will you call it? A void agreement or a void contract, because it had already become a contract. So this is what Jay is saying, that this will be called void contract, because it had the opportunity of becoming a contract and it became void only after it had already become a legally enforceable contract. So it will become void, that is for sure, but it will be called a void contract. But as far as G is concerned, when from the very inception an agreement is illegal, so it never became a contract, it will be called void agreement. Okay, so this was our discussion for today, friends. We discussed very important definition. So friends, if you want to appreciate my efforts, please subscribe to my YouTube channel, connect with me on Telegram. The invitation link is in the description to the video. Until then, friends, be safe, be happy. Bye bye. I will see you very soon.